Thank you, Dave.
Good morning, everybody. Welcome to the First District Court of Appeals. We have 3 cases on our docket this morning. 2 are to be argued. The first case to be argued this morning is Vandekar versus the Port Authority of Cincinnati. Counsel, you are already at counsel table, I see. The port is represented today by Mr. Buell. Vandekar is represented by Ms. Bryan. There is an appeal and a cross appeal. We have discussed this, the panel has discussed this before coming out today, and I think I'm going to give each side 20 minutes. You can divide it as you see fit, but each side will have a right of rebuttal and reply. So, Mr. Buell, whenever you're ready, and let me know how much time you'd like to reserve.
Morning, Your Honor.
Good morning.
I'd like to reserve 5 minutes for rebuttal if we're doing 20 minutes, please.
All right.
And if I may introduce our client, my co-counsel, please.
Yes?
Back with me here, we have the Port's Chief Executive Officer and President, Laura Brunner, Port's Vice President and General Counsel, Christopher Recht, and my co-counsel, Matt Chiricosta.
All right, whenever you're ready. If you'll keep your voice up, that was difficult to hear, so thank you.
Yes. May it please the Court. This Court should reverse the trial court's decision granting summary judgment in favor of Vandekar on count 1 and render judgment to the Port on that count. Or,
Let me stop you there. Is our sound system on? Is his microphone on? All right.
I was going to say it's particularly hard behind to hear.
Yeah, can you raise the microphone a little bit? See if that helps.
test it out. Hello? I can barely hear it too.
That was better when you got really close, but I'm not going to make you lean over the microphone.
I'll do my best.
Thank you.
I think I raised my voice.
I'm adding a minute back on to your time, so whenever you're ready.
Start over if you don't mind. May it please the Court. This Court should reverse the trial court's decision granting summary judgment in favor of Vandekar and render judgment to the Port on count 1, or reverse and remand and send that count back to the trial court for a jury trial. With respect to the cross appeal, this Court should affirm the trial court's additional rulings denying Vandekar's motion for prejudgment interest and granting the Port's 12C motion dismissing the bad faith claim. The trial court made a $5 million error in this case, and this Court reviews that decision de novo. That de novo review allows this Court, and the Court must, independently review the trial court's decision, giving no deference to the trial court. And when it does so, under that de novo standard, this Court should reverse the trial court's decision on count 1 and render judgment for the Port for 3 reasons. First, the trial court erred as a matter of law when it supplanted unambiguous, multi-word, contractually defined phrases or dictionary definitions out of context.
I guess what I don't understand about that part of your argument is, yes, they are defined terms within the contract. However, the word redevelopment is not defined in terms of like, what does that mean, which seems to be the crux of the dispute. So if we don't have a precise definition for redevelopment itself, then don't we need to look at a dictionary to help elucidate what the meaning is?
Respectfully, Your Honor, no, and the reason is because the Court has to read the contract as a whole. And the multi-word phrase is redevelopment bonds, and that is tied back in Recital C to the first part of Recital C, where it says the Port wishes to acquire Millennium Hotel and redevelop the real property for a new hotel. So redevelopment ties back to for a new hotel. The key phrase is undoubtedly for a new hotel.
But if we accept your argument, the bonds were issued for three purposes: the acquisition of the property, the demolition of the property, and evaluation of the property. Is it your position that the evaluation portion of those revenue bonds is also acquisition as opposed to redevelopment?
No, Your Honor, and that's another error on the trial court's part, and that is because the trial court ignored the full definition of property acquisition bonds and the full definition of redevelopment bond and instead looked to lowercase acquisition and said acquisition means acquisition. Taking that to its logical conclusion, if that were true, Vanderkar would not be entitled to the $2.5 million fee. That was not part of the purchase price in the underlying purchase agreement. It was $36 million, not $38.5. Vanderkar also would not have received its reimbursement of $472,000 of expenses, which it did. Both of those are undisputed. So the trial court ignored that in favor of looking at dictionary definitions, which violates the bedrock principle that contract definitions trump dictionary definitions, and the court only looks to dictionary definitions if the terms are undefined. Those terms,
They are undefined.
respectfully, Your Honor, the term property acquisition bonds,
Well,
capital P.
but getting back to my question, how would you define under this contract the word redevelopment? And then you can set it in context with bond, but how do you define redevelopment?
It has to be redevelopment of the new hotel. So let's use the trial court's definition. Trial court and Vanderkar have argued that redevelopment means replacing old buildings with new buildings. And the and is the key. And both Vanderkar and the trial court read that word out of their own definitions of redevelopment. All that happened was demolition of the old hotel. There is no dispute whatsoever that there were no bonds issued for a new hotel. So there's been no replacement.
Well, there were bonds issued, as I said, for those three things, some of which, and I'm not sure you answered the question, that third piece, the evaluation, is it your position that that portion of those revenue bonds was related to redevelopment, or is it your position that was related also to the acquisition?
So respectfully, I answered Your Honor Bergeron's question. You're right, I did not answer your question. And the answer to that
I interrupted, I apologize.
and the answer to that is the evaluation doesn't have to be part of acquisition.
And that's because the contract provides for the issuance of bonds. They can be in several series, they can be in different lots, and you would agree if the contract had so provided in your argument that you could have issued revenue bonds that would cover both acquisition and redevelopment at the same time. You didn't have to have two separate bond issues.
Absolutely. There's a binary choice. It's one or two. But going back to your point about evaluation, that is another area where, again, the trial court erred in ignoring language. The language is different. For property acquisition bonds, it says those may be used to acquire the property, whereas redevelopment bonds, it will be used. That's mandatory. It's permissive. So it wasn't required to use those only for acquisition, and they didn't have to use them at all. The trigger on the $2.5 million at the closing was just simply the closing of the Millennium Hotel property, and that's what happened. So to answer your question, it is not redevelopment to say that they were evaluating anything. That doesn't mean that redevelopment was going to occur. In fact, redevelopment may never occur. There's nothing there today. There's just a hole in the ground. And that goes to the court's main point here, which is using the trial court's definitions of taking old buildings and replacing them with new ones. There is no new building. There's a hole in the ground. There's been only demolition.
But I think the problem, though, is if you have an existing building and you're going to redevelop it, and that the premise is upon the destruction of the initial building, you have to destroy it first to be in a position to redevelop it. And you might just, like, I'm not an engineer, but you might destroy it in certain ways or remove it in certain ways, like, hey, we want to leave the foundation here because that's going to help us build this new hotel or something like that. But, like, you could have contractually broken this into three parts, which is property acquisition, demolition, and then redevelopment. But failing to break it into three parts then leaves open the possibility that redevelopment encompasses both the demolition and the construction of the new hotel.
So several points there. Your Honor is absolutely correct. The parties could have triggered the $5 million fee solely by defining the trigger as demolition bonds, capital D, capital B. They didn't. And so what we're left with is what's in the contract. The reason they didn't is because everything leading up to it, when they were discussing the due diligence, every single document that came from Vanderkar tied acquisition to demolition in a separate part, whether it's Mr. Smyjunis's email that says land cost and ties those together, the construction schedules, the budgets, everything leading up to the contract being
We
signed.
don't get there, do we?
Yeah.
I mean, I mean, I understand your argument about the use of extrinsic evidence, but this is a heavily negotiated, well-lawyered contract that, I mean, we should not be going into that unless it's absolutely worst-case scenario.
Absolutely. And so going back to your question about the three parts, yes, they could have done that. And had they done that, the entirety of paragraph 5 would have been negated. But they didn't because they wanted paragraph 5 in there to have alternative triggers on redevelopment bonds. So you look at the redevelopment bonds in the recital C, and you look at paragraph 5, and that phrase is used again 5 separate times. They talk about alternative triggers. There's one that's transferring to property that's not an issue here, but it all goes back to the redevelopment bonds, and that's the "the" is a word of limitation. So they could have done this in one issuance or two, as Your Honor noted earlier, and the port did it, intended to do it in 2, because
The term acquisition, just acquisition, that is not defined at all in the contract, correct? Okay. So I'm struggling to understand how you're getting to property acquisition bonds, meaning demolition. And I'm looking at the paragraph that you were referring to right now, and I'm still struggling to understand if the word acquisition is not defined in this contract, why couldn't the trial court have looked at the dictionary definitions?
So I'll answer this in 2 parts, Your Honor. Respectfully, they could have looked at dictionary definitions if there were no defined terms whatsoever. There's no case law that says if you have a defined term that's multi-phrase, you have to look at the definition of each of those terms individually. That would trump the party's intent in how they defined it in the contract. Here, to answer the question about property acquisition bonds, the court has to look at what does redevelopment bonds say, because redevelopment bonds is inextricably tied to new hotel. If there's no financing for a new hotel, it defeats the entire purpose of the agreement, and that is because this was a $5 million success fee for issuing bonds for a new hotel. The trial court turned this into a $5 million windfall for destruction of the old hotel. Under the trial court's interpretation, it skipped its own second part of what you necessarily need for redevelopment, which is and replacement of old buildings with new ones.
When I'm looking at the assignment agreement, it defines the project, it defines property acquisition bonds, and this is in paragraph C, and it defines property acquisition bonds as acquisition of the real property may be financed with the proceeds of revenue bonds issued by the port. Property acquisition bonds, acquisition. And then it says redevelopment will be financed with proceeds of revenue bonds issued by the port. Redevelopment bonds, there's no definition of redevelopment or redevelopment bonds anywhere other than that, is there?
There is no definition of lowercase redevelopment in the contract because the parties didn't intend to go to a dictionary and say, what does redevelopment mean? So to answer that question, it is redevelopment bonds. To answer the question about acquisition and what does that mean, that goes back to, and I'm looking at the same language here in recital C, such acquisition may be financed with property acquisition bonds. So the port was not limited in 2 ways. 1, it didn't have to use bonds at all to acquire the property. And 2,
But it did.
And 2, yes, Your Honor, it did. And if it did, it was not limited into how to use those bonds other than they could not use them for redevelopment of a new hotel, which is in recital C, but it's also buttressed by paragraph 5, which says that the port shall not use or allow to be used any other method of financing of the development of the project unless such financing causes and allows for the payment of the $5 million redevelopment fee. So it again goes to, they were focused on redevelopment, and there's a limitation on what you can do for the redevelopment bonds. There is no such limitation for property acquisition bonds. Now,
You have 2 minutes left if you want to reserve 5.
thank you, Your Honor. I do want to say, a couple of other things while I'm up here on the initial part, and I'm happy to answer any questions now or in rebuttal on the cross-appeal issues. But another error that the trial court made in this case was it inexplicably reversed its 12C decision.
Well, let me stop you there. You're not suggesting, are you, that you argued in summary judgment that the contract was clear and unambiguous?
Yes.
You're not suggesting that because the court initially didn't find it clear and unambiguous or wasn't sure if it was clear and unambiguous, that it can't later find it clear and unambiguous, are you?
Absolutely not, Your Honor.
Because courts can make errors and, maybe the judge was sitting in her chambers, I know it's a him, he was sitting in his chambers and said, this is clear and unambiguous. I should have granted that. Now I'm going to grant summary judgment.
Yes, Your Honor, and that's the rub. We're under Rule 56, which requires reasonable minds can only come to one conclusion, and that conclusion is adverse to the non-moving party. Here, the trial court found, looking only at the contract language of 12C, there was an ambiguity. Then at summary judgment, Your Honor, made very clear he was only looking at the contract again, went out of his way to say, I considered zero extrinsic evidence. I now find it's unambiguous. That is the same reasonable mind reaching two different conclusions on the same contract language.
Well,
But you're saying it was clear and unambiguous. So you say he got it right, he just got it right for the wrong party.
That's our position, is it is clear and unambiguous. It's in the court's favor and no reasonable.
But I think I don't see a conflict because in the 12C decision, it's not like he came to the opposite conclusion and said it's clear and unambiguous in your favor, right? He just said there's disputes of facts and it's premature to resolve it here.
Correct. The issue is Vanderkar itself raised the contract language and said, you don't need to look at anything else. Look at the contract language. And
I can't tell you how many times I made those same arguments when I was in practice at the motion to dismiss stage and they were rejected. And then, the court wanted to see how it got played out at summary judgment.
And that is the tragedy of this case. The court sent the parties for a year and a half to do discovery and came back and said none of that discovery matters. I'm not going to consider any of it. The parties hired experts. They spent hundreds of thousands of dollars for the trial court to look at the same language and say, at this stage, I find an ambiguity. At this stage, I don't, and it's actually in the other party's favor. On top of that, and I'm not arguing in the initial instance it's unambiguous, but to address that issue, Vanderkar forced the port to address the potential ambiguity from the very beginning. It attached mountains of evidence.
I hear what you're saying, and I can empathize with that predicament, but, what are we supposed to do with that? There's legions of cases where motions to dismiss, maybe should have been granted, and the parties were forced to go through summary judgment and discovery, and, it's an interlocutory decision. There's nothing you can do about it. There's nothing we can do about it now.
Absolutely. The issue that we see here, in addition to essentially reversing on just the same contract language, is Vanderkar adduced no evidence whatsoever supporting its position and attached the same evidence to its complaint, its 12C motion, which was inappropriate, and it did it again at summary judgment. It's appropriate at summary judgment. It's the same evidence. All of the evidence they attached has nothing to do with this project. Every single piece they attached are unrelated projects that have nothing to do with this case. So the court had in front of it, at that stage, everything. Now, it said it was ruling on just the contract language, but it had everything it had at summary judgment, and nothing changed. There's no way to reconcile those decisions, and it leads to the conclusion that you can at least read this contract two different ways, because the trial judge did.
And you are at your time, but I am going to let the panel ask any follow-up questions before we let you sit down. Any other questions at this point?
Thank you. We ask the
Thank
court
you.
to reverse on count one.
Ms. Bryan, of your 20 minutes, would you like to reserve any for rebuttal?
How much did they reserve? 3? 5?
They reserve 5.
Just 2.
All right. Whenever you're ready.
May it please the court, Beth Bryan from Taft, Tinius, and Hollister, representing Appellee Vanderkar Holdings and cross appellant. I'm going to address all 3 points in my argument this morning, starting with the breach of contract. And I want to start off by a question from you, Judge Bergeron, about the meaning of the contract here and the idea that we can't use dictionary definitions. I just heard Mr. Buell say that there is no case law that allows you to use dictionary definitions in this context. And what I would say is cases that they attached to their brief did exactly what Vanderkar asked the court to do and what the trial court did. The Bank of Mellon case is exactly on point here. In that case, the parties had agreed in their contract to define the term material breach. One of the parties didn't like the agreed upon definition, so they went to Black's Law Dictionary and said, use this definition instead. And the court said, no, we can't do that. We have to use the defined term. But then within the defined term in the contract, the parties used the word material. And the court didn't know what material meant, so they went to Black's Law Dictionary and used material to define the term. That's exactly what we have here. The terms redevelopment bond and property acquisition
Right.
bonds.
I guess the question, in I think where he was pushing back, is the notion that there's a distinction between small r redevelopment and capital R redevelopment bond. And I think what he was finding fault with for the trial court was kind of disaggregating those two. So how do you respond to that?
Sure. The court agrees that the only proper construction of redevelopment bonds is to revenue bond proceeds used to redevelop or cause to be redeveloped the real property for a new hotel. Say it in page 20, page 36 of their opening brief. That's our construction too. So then the question is, what do you have to have done to redevelop the real property for a new hotel? And everybody agrees, Ms. Brunner testified, that to have that happen, you have to demolish the old hotel. There is no dispute about it. She says it at page 202 of her deposition.
We don't even look at that, do we?
No, you don't have to. I mean, the question is, what is the definition of redevelopment as used in that phrase, to redevelop or cause to be redeveloped to real property? And it means to tear down an old building and replace it with a new one. That's the common definition of redevelopment. Your other point, Judge Myers, about the extra money that was used. So they used the revenue bond proceeds for 3 things: acquisition, site studies, and then demolition. In the site studies, everybody also agrees that that's the beginning of redevelopment. The port's expert wrote an expert report, again, extrinsic evidence, but saying this is also redevelopment. So it's not just the demolition that falls into that bucket.
So your position is if they had not done the demolition, but the bonds had been simply the acquisition and the site study, that
Yes.
would be enough to trigger it?
Yes, by their own expert's admission, yes, that would be enough to trigger the redevelopment. Of course, they did demolition. They took that extra
Sure,
step.
I understand.
So we have both of them. But that's also in the record trial court, in the event that you wanted to go and look at extrinsic evidence. I want to address this other idea about the word "the" and issuing them only at one time, and how that played out, and the concept that "the" is a word of limitation. It's not. There's no case law that suggests that it's a word of limitation. It's just using the word for the defined term.
Would you agree that if everyone had chosen to do it, there could have been a series of bond issues, maybe 3 or 4. One to simply acquire as the dictionary term is. Another maybe to demolish. Another to do a feasibility study and run some pro formas. That would be maybe kind of silly, but could have done that. And then a fourth to construct a new structure.
Sure, they could have set up.
They could have had as many as they wanted.
Absolutely. They could have set up a completely different structure. They didn't. What they did was, if you go back and look at the common definition of redevelopment, including, we cited the trial court, the statutes, acquisition is normally part of redevelopment. It's actually normally the first step. And what they did here was they carved out that step and said, if we just acquire the property, you're going to get $2.5 million. Then if we do any other step in redevelopment, you're going to get the extra 5.
And
That's the way it played
if
out.
I'm going into the marketplace to purchase these bonds, I only know they're revenue bonds, and I have the document maybe in front of me of the resolution to issue them, but I'm not buying a redevelopment bond.
Correct,
I'm not buying an acquisition bond. I'm buying a revenue bond
correct.
for this purpose in this resolution.
Right. The concepts of redevelopment bonds and property acquisition bonds, those don't exist anywhere in Ohio law. Those are just a creature of this contract. So for the person buying the bond, it's meaningless. And it's important here, the port's argument is that they voluntarily limited their right to issue a number of redevelopment bonds, and they've given no explanation as to why they would limit that right. And the port, I don't think, believes that they cannot issue any more revenue bonds to develop that site at this point, or to finish redeveloping that site. I would argue it's not a hole in the ground. It's a lovely green space now with park benches out there. But it didn't limit its power within that contract. Unless you all have any more questions about the contract, I'd like to move on to our cross appeal.
I have a question about I guess it's part of your cross appeal, but the complaint alleges a second cause of action called bad faith. Is there such a cause of action in Ohio? Or is what you're arguing that this is implied in every contract is an obligation of good faith?
Okay, so in Ohio has long recognized that there can be, a party can recover attorney's fees if the other party breaches the contract in bad faith. We are not alleging that this is a standalone claim. You have to have an underlying contract breach. But what I will say is that the case law, the Ohio Supreme Court case of Soren versus Westerville Board of Education says that you have to allege bad faith breach of contract.
Well, but are you saying bad faith as an exception to the American rule, or are you saying there's a separate doctrine that says you breach a contract in bad faith, you automatically get attorney's fees regardless of your litigation conduct?
Under the way the law has developed in Ohio, you can get fees for the way your bad faith in the litigation conduct, bad faith before and how you carried out the contract and how you breached the contract. That's the Twin City fan case from this court. And Judge Myers, back to your question about pleading it, we went back and we looked. Twin City fan has a separate allegation related to bad faith, but the Covenant Dove case that the port likes to cite, that was a complaint filed by now Justice Pat Fisher, and he laid out his allegations the exact same way we did. Breach of contract, specific performance, bad faith for attorney's fees. We have to put them on notice that we're seeking the claim.
Right, but I have a difficulty in understanding what the limits of, as you articulate this, would be, because like every contractual squabble is going to have allegations of bad faith. They did this, they did that. And if suddenly that opens up the losing party to an attorney's fee award, then we're effectively just throwing the American rule out the door. And I mean, again, you guys are really sophisticated. You had really detailed contract. I didn't see a fee shifting clause in there. Could have included that.
Well, Judge Bergeron, that's a question of whether the idea that you could get attorney's fees for bad faith conduct should be the law or not. And Taft was the party in Twin City fan. We took it up to the Supreme Court and they rejected it. So right now it is a claim that is recognized. And I understand the question about limitations. Right. The reality is it exists in Ohio law. And so the question is, did we plead enough to survive a motion for judgment on the pleadings on that? And what the court did, they didn't look at our pleadings. What they said was there could never be bad faith here because there's a force majeure and because there's we don't know if the fee would ever be paid. They didn't look at our allegation about what the court was actually doing to get around that provision.
Okay, so on that, reading your complaint, to me, I'm struggling with what facts you actually put forward that would justify, if this claim actually is available, to justify that claim. Because, I mean, there's a conclusory statement that the port intended to mislead your client. But beyond that, are there facts pleaded in your complaint that would back that up?
Sure. So when you go and look at the complaint, what we put in the court, the misleading of the client comes from, or misleading of Vanderkar comes from the allegation that the port was trying to hide what they were doing with these revenue bonds to avoid showing that they had triggered the fee. So what we did was we put in the bond offering documents where they said, we're going to use these bonds for acquisition, site studies, and different things. Now, it's important because under Ohio law, the port is only allowed to issue bonds for certain reasons: construction, equipping real property, improving real property, and acquiring real property. So under their own definitions, we know it's not just for acquisition, and we know that we're not equipping real property. So that leaves the definitions of construction and improving. Neither one are anything that the port wanted to admit that they were doing. So they were hiding what they were doing with those bonds, and what we alleged was that's deceitful and it's dishonest, and that is the definition of bad faith and how you carry out your
Are you
contract.
saying their bond offerings were false and misleading?
I'm saying that what the port did was they didn't put the language in there, and then what they argued was they can't be redevelopment bonds because we didn't put the word redevelopment in the bond offering. They were very careful to not include the word redevelopment in there because they didn't want to trigger the payment, and that's their allegation.
But like, again, to me, that doesn't sound like bad faith. It sounds like strategic action on behalf of a party who wants to avoid an additional charge. Like, why that? I mean,
I understand the hesitation, and I understand where it comes from and the idea of the American rule shifting. Like I said, the question is, did we plead within the rules of bad faith as the law has developed, and it's conscious knowing wrongdoing, disregard of your contractual duties, and that's what we pled.
So if we were to accept your argument in total on every claim, you would want us to affirm the trial court's decision on the breach of contract claim, send it back to the trial court for a determination on the merits of the bad faith allegation.
Correct.
And order prejudgment interest if appropriate.
Correct. And I do want to briefly address prejudgment interest. I'm not sure how much time I have left, but
You have 8 minutes because you only reserved 2.
Okay. The prejudgment interest piece, I think that's clear error by the court. What we laid out in our papers is the statute that creates the Port Authority. It was passed in 1955. And in 1927, the Ohio Supreme Court stripped all Ohio entities of sovereign immunity for proprietary actions. They don't have any sovereign immunity when they engage in proprietary acts.
But doesn't the sovereign immunity statute only apply to tort actions? We're not even talking about sovereign immunity in the tort sense.
It's sovereign. This is sovereign immunity. The decision denying prejudgment interest comes from the remnants of sovereign immunity. Otherwise, the port would just be coming in like any other litigant under the statute that allows them to sue and be sued. There wouldn't be a reason to deny them prejudgment interest. The case that the port relies on, Bifus, is a 1988 decision, and that case has been expressly limited by the Supreme Court in 1993 in the Ziegler case. And basically if we track through what happened, and let me back up. That case doesn't even apply to this setting here, I would argue. The statute creating the port authorities specifically says you're going to engage in essential government functions, but you're going to be entitled to no immunity by reason thereof. That language can't be read out of the statute, that they're not immune for any reason. So they're not immune for when they engage in proprietary function. They're not immune when they engage in government function. So the statutes awarding prejudgment interest should apply. That statute denying them immunity is very different from the statute that creates school boards. It doesn't have the same language that says you're not entitled to any immunity by reason thereof. And as the case law is developed, Bifus initially, when it was decided, Andy Douglas.
And was that a based on common law, like immunity based on the common law as opposed to statute? Or am I misremembering?
Bifus, was it based on common?
Yeah.
No, the majority isn't clear about where the immunity is coming from.
Okay.
Andy Douglas, in dissenting, says that they shouldn't have any immunity because of the statute that creating the school board said they can sue and be sued.
Right.
So as that case law developed, 3 years later, in the case of Tavener versus State X-Rail, Indian Lake, another school board is sued.
We normally think of sovereign immunity as statutory based.
Right.
And that way we kind of look and see, does an exception apply here? Or
right. Right. And I think the concept that the port has created is that they are actually in a better position than any other state entity. They're not going to be sued in the Court of Claims, which is very clear that they're going to get prejudgment interest if you're there. Instead, they've created this setting where they're actually in a better position than the state with no explanation as to why. And it doesn't come back from their statutes that authorize them to be created. And they didn't address our argument about engaging in the proprietary function and why they should not be subject to prejudgment interest there. They just ignored, I would say that their brief was non-responsive to the arguments that we raised on both points. And I think it's important because what we're saying here is that the port knowingly breached a set amount, and they are now saying that they are better off than every other litigant, and that's going to affect private parties' abilities to enter into contracts with the court. They're not being held to the same standard as every other litigant. And if you go and look at the prejudgment interest statute, when you get in there at the end, the Supreme Court has come back and said even a school board can be held liable for post-judgment interest under that statute, and has specifically limited BIFAS, basically said it's sui generis. It only applies to school boards and wage disputes. So we're just back to the regular question.
Well, I guess that was a question that occurred to me is like, is there a distinction between prejudgment interest and post-judgment interest for purposes of immunity here?
There isn't really, because the Supreme Court, tracking through those cases, starting with BIFAS, then going to State Ex Rel Taverner, and then going to Wendell versus Ziegler, what they have said is, the last case, Ziegler, they specifically say that the appellate court limited that case just to its facts, which is prejudgment interest against a school board in a wage dispute. And so there's nothing left of that remnant of that authority at this point. It wouldn't apply in this case by the Supreme Court's own pronouncement. If the court doesn't have any other questions, I'm happy to reserve the rest of my time if I need it.
Question? All right, you'll have 5 minutes remaining.
Thank you.
Mr. Buelos, you have 5 minutes.
I'd like to address several points that were raised by Vanderkar in their opposition. But first, I'd like to make very clear the court stands on its briefing with respect to the cross-appeal issues. With respect to bad faith, the court was correct when it granted the port's motion for judgment on the pleadings on that case. That's a common law doctrine. It's very extreme, limited circumstances. And as Judge Bach pointed out, there are no specific allegations that allowed the court to infer bad faith. The court said there is no indication of bad faith. And again, they had all the materials in front of them that Vanderkar later presented at summary judgment in opposing the port's motion there. The standard they keep citing, and that they cited in their briefs, is this no justification standard. That is not a standard. They cite SST. SST does not contain those words. That they want to take that standard and make it really low. So as Judge Bergeron noted, you could include in every case, the argument that someone intentionally breached. Every breach is intentional. That doesn't make it bad faith, and there are no allegations here. What there are conclusory statements about future conduct, what might happen in a year. We believe the port is going to take the position a year from now that they didn't issue redevelopment bonds. That's not a justiciable issue.
Perhaps I should have asked Ms. Bryant this question, but I'll ask it to you. Isn't the case law in Ohio on bad faith implied in every contract? That's when there's a discretion on the part of one of the contracting people. And here, we don't have anything that the port had in its discretion. I mean, it wasn't a discretionary payment. It was it either was or wasn't due. So again, I guess it's another argument on why good faith might not apply in this case, even on the pleadings.
So to answer the question, I'll answer it in two parts. One, yes, there's a covenant of good faith and fair dealing. You don't get to say, I get attorney's fees because you breached in bad faith. You're just saying you breached the contract intentionally. But there's a different kind of discretion. There's not a discretion to pay or not pay the fee. there is, the words at the port's discretion are in recital C. And that was totally up to the port's discretion to issue one bond issuance or two, to choose to do those at the same date or at two different dates. It does say in the port's
Or
discretion.
3 or 4.
Respectfully, Your Honor, again, the word "the" is a word of limitation. They cited the bank, they said there was no case law whatsoever for that position. Port cited 2 cases that were direct quotes that "the" is a word of limitation on page 23 of the brief. So it's the redevelopment bonds and the property acquisition bonds. There's nothing consistently in paragraph 5 that says you can issue some or any, a little bit here, a little bit there, which are the words they use in their brief. Those aren't found in the contract. Again, 5 times it says the redevelopment bonds.
Well, then what are the redevelopment bonds? Because these revenue bonds included site evaluation, maybe some financial evaluation. Isn't that redevelopment bonds? So is your position the port can issue no more bonds to finance this project?
So respectfully, to answer that in 2 parts. One, evaluation studies does not show there's redevelopment. That just shows we're trying to figure out if we can redevelop something. The answer might be no. Today,
So is that acquisition or redevelopment?
it doesn't have to be one or the other. And that's because, again, property acquisition bonds are not limited to acquisition itself. It says maybe financing. That's a 2-part permissive. We don't have to use bonds at all to pay for it. We did. And then we're not limited to just acquisition. Again, taking that to its logical conclusion, they would not be entitled to their $2.5 million fee. That was not acquisition. They would not be entitled to their expenses. That was not acquisition. It's Mr. Smijunas who negotiated a $36 million price with the underlying purchase agreement with the Millennium Hotel owner. To that end, that agreement also says that they were entering into it to facilitate the redevelopment of a new hotel. So consistent with that, that's what this agreement says, for a new hotel. The port did not issue any bonds for a new hotel, and therefore it didn't issue redevelopment bonds. It's right in the contract. We're not asking by any means for a rewrite of the contract. I want to quote from Vanderkar's opposition to the port's motion for summary judgment, brief at 18. The demolition costs are part of the cost to acquire the, quote, real property. Those costs are expenses that the port issued bonds to pay for. That's exactly what the port is arguing. So everybody knew the demolition was going to go with acquisition. Secondly, the port and Vanderkar agree, and this is Vanderkar's opposition to the motion for summary judgment, this is TD 64 at 13, building a new hotel was always what the parties contemplated. The port again agrees. That's exactly what was in the purchase agreement, which is why it's also in the assignment agreement. So we've gone from a $5 million success fee, which is if his plan works, if Mr. Smijunas' plan works, if he can do this all, you get your $5 million fee. That's exactly what the port was going to do if that's how it works. If it doesn't, you at least get your $2.5 million fee. But everything goes to a new hotel. And we've changed from a success fee to a windfall for destruction of the old hotel. There's been no replacement, no new hotel. That doesn't.
Couldn't that have been spelled out very clearly in the contract?
Absolutely. The parties could have.
And you would agree what you just articulated is not the language of the contract?
Respectfully, which part?
The part about when you get your fee. You get your fee when we build a new hotel. It doesn't say that.
It doesn't say the word build. It doesn't have to. Respectfully, it says redevelopment bonds for a new hotel. Nobody here can take the position that bonds were issued for a new hotel. Not a single dollar has gone to anything involving a new hotel.
But I guess getting back to like your windfall point, if the port is a rational actor, then they wouldn't demolish the new hotel without a plan to do something with that property. In other words, like if the idea was to build a new hotel, you wouldn't destroy the initial one without planning to take that next step.
Respectfully, Your Honor, I think the contract allows for it, and they could decide to do nothing. That hasn't been determined yet. They could decide to do nothing because that's why there was a $2.5 million guaranteed fee just for the closing. The trial court was correct in this instance where it said they absolutely contemplated that $5 million fee might not be paid. And to your point, there may be no new hotel. And again, The port had 2 weeks to do due diligence on this massive project, and so all they had in front of them were the PowerPoint presentations, the budgets, the schedules, everything from Vanderkar to consider. They considered all of that, and all of it said acquisition goes with demolition in a completely separate part from everything else relating to the new hotel. And that was because they needed to everybody wanted to get that hotel down. Port agrees with Vanderkar on that point. They're correct in the complaint. Everybody, the city leaders, the county, all the stakeholders wanted to get that hotel down. It was a blight and it's down. That doesn't mean, that's destruction. That's not redevelopment. And so whether it's a hole in the ground or whether there's grass over it, there's no new hotel and no new bonds have been issued. To Your Honor's question about, does this mean that they can't issue new bonds? They haven't issued new bonds, and it's unclear whether that's going to happen in the future. But the contract says they're limited. And so we've got an opportunistic plaintiff here trying to take advantage of contract language their attorney helped draft. So both parties were represented here. Both parties absolutely had the option to do demolition bonds. It would have been much clearer. But paragraph 5 was the crux of the negotiations, because there's all these different alternative ways to trigger the fee based on the $5 million, based on the redevelopment bonds. And so if you look back then to recital C, everything about redevelopment bonds talks about a new hotel. And that's why it's a success fee. It's not a success, and the port would not argue a success here to say we've demolished the building and now there's a grassy knoll and it may never become a hotel. That just means that the port achieved the purpose of acquiring the property, which it had with Vanderkar, and that achieved the purpose of demolishing it, which it had with Vanderkar, and which it had with the city and everybody else. It does not mean they redeveloped it into anything.
And you are 4 minutes over your time at this point. I let you finish that thought.
Can I ask one
may.
final question?
I actually wanted to as well.
Sorry. Just one question on the prejudgment interest, just to make sure I understand. Is your theory common law based or statutory for the imposition for your immunity from prejudgment interest?
So to make clear, first, the Bifus case is a common law rule.
Right.
The port, this entire argument is a straw man. The port and the court never once argued sovereign immunity. The fact that they can cite cases and say, well, this case also talked about sovereign immunity, they added a parenthetical to the judge's decision that talked about sovereign immunity. The judge didn't hook his decision to sovereign immunity. That's not an argument the port is making. The port absolutely got sued here and didn't take the position that it was immune from liability, but the port is an arm of the state. Bifus has not been overruled. Bifus has not been limited, as they say. Bifus is still good law, and Bifus says if you are an arm of the state, prejudgment interest cannot be issued against you.
And the origin of that is common law.
Yes,
That's what you're
it
saying.
is a common law, judge-created exception, and to your point, Your Honor, if the parties intended prejudgment interest, the parties could have put it in the contract. They didn't, just like the attorney's fee issue.
Okay, so the statute says no port authority is immune from liability by reason of being essential government functions. So can you point to any case law that contains similar language to that in which the court found that because it's a state entity, an arm of the state, there's no prejudgment interest?
Because it's an arm, that's Bifus. To answer that question, that's Bifus.
But does it contain the same language? Does the statute, the Bifus was about school boards, correct?
Correct.
Does any statute involving school boards contain language similar to 458222, which says that the port authority shall be considered to be essential government functions of the state, but no port authority is immune from liability by reason thereof?
So the answer to the question is no, because the courts haven't had a rule on this. This is obviously an arm of the state, and that would take every political subdivision and subject them to prejudgment interest. There's a reason that governmental entities are...
Only in contract cases.
Correct. And to your point, Your Honor, this was derived out of tort liability. It was not an add-on to subject governmental entities or arms of the state to prejudgment interest. If the General Assembly wanted to do that, they've had 34 years since Bifus to do it, and they haven't. So on that point, there's nothing that would allow prejudgment interest to be issued against the port, and the lack of a statute it's almost like they're trying to get us to prove a negative. There's no other statute that says this, and there's no other statute that says the port isn't subject to it. To Judge Bergeron's point, it's a common law rule. It's still good law. BIFAS is still on the books. BIFAS hasn't been limited, and the General Assembly has had plenty of time. I heard a notion that the port wants this scenario where they get to be not subject to the jurisdiction of the Court of Claims, where prejudgment interest can be issued, and that they are not subject to it here. Respectfully, that is not the port's decision. It's the General Assembly's, and we ask the court to affirm on that front.
Thank you. Any other questions? Thank you. Ms. Bryant, you have 5 minutes remaining.
I want to start with this last point about the question of whether BIFAS comes from the common law or whether it comes from something else. BIFAS comes, first paragraph here, second paragraph, I'm sorry, of the opinion. It's well established that in the absence of a statute requiring it or a promise to pay it, interest cannot be adjudged against the state for delay in payment of the money. Cite State Ex Rel Parrott versus Board of Public Works. That is a sovereign immunity case. This question is solely related to sovereign immunity, and it strips the General Assembly, when they created port authorities in 1955 from the get-go, stripped all port authorities of sovereign immunity. And it continued. It reauthorized the statute in 1987, still stripped them of their sovereign immunity. This port wasn't formed until 2000. It has never had sovereign immunity for performing essential government functions. I want to also address Judge Bach, your question about is there a case that interprets this statute, no immunity by reason thereof? The only case that we could find was a common pleas case, and it involved the Ohio Turnpike and Infrastructure Commission. There are 5 state government agencies that have similar language, that the no immunity by reason thereof, and this was just a common pleas decision that we found, but interpreted the statute the same way. I can't remember the exact name, but it was the Ohio Infrastructure and Commission Authority, a common pleas case. Judge Myers, your question about the bad faith claim and whether this is, I think it was, you were getting at, it's akin to the duty of good faith and fair dealing. I think it's slightly different in this context, but not all that different. And you said they didn't have any discretion here. The port didn't have any discretion here. The port, you're right, didn't have discretion to pay the money or not. That's why the implied covenant of good faith and fair dealing concept doesn't necessarily apply here. It's just a question of when they performed this contract, did they perform it in bad faith? And did they do things that, meet the definition of bad faith, which is a dishonest purpose, moral obliquity, conscious wrongdoing, breach of a known duty due
but
to an
I guess
ulterior motive.
I think the thing I'm still hung up on this is if you're a counterparty to a contract and you say, we could do this and we have liability to the other party, or we could do it this way and maybe we don't. Like, how does that become bad faith? I mean, that's just like rational action.
Well, that's a different question than what happened here. I understand. Again, I know why you're struggling with this concept, because you're struggling with the concept generally about bad faith and breach of contracts. And again, Taft made this argument to the Supreme Court and we lost, and we said what's going to happen are people are going to bring this claim. The question is, did we plead it with enough certainty to survive? And we have to make allegations of bad faith. And I think it's important, too, to step back here and think about how this case developed, because procedurally it's a little bit unique. We filed the case in February of 2020. The port didn't even move. They didn't file their partial judgment on the pleadings until May of 2021. So 18 months later, 15 months, 18 months later, 3 months before discovery ended. And what they said was, this isn't a standalone claim. Not that we didn't plead enough, just that it was not a standalone claim.
Aren't they right about that?
No, I mean, the reality is, if they're correct about that, it doesn't stand on its own because you have to have an underlying breach. But we have to plead allegations of bad faith or we can't get the attorney's fees. So what we said was, if this is right, then we'll file an amended complaint and we'll strip the header out for count 3 and leave everything else alone. What they're doing is really elevating form over substance and say, if you put us on notice under Rule 8, as we're required to do, that you want these fees, it should be dismissed with prejudice because you were too formal in how you pled it out. And again, I go back to the Covenant Dove Holdings case where now Justice Fisher pled it the exact same way that we did. And the question is, what is the right answer here in terms of pleading? We know we have to put it on. And if the court thought that it wasn't a standalone claim, which is not what they decided, the answer is, again, to strip the claim. We also have the other piece in our prayer for relief, if you think you don't have to plead it out as a standalone claim, where we ask for attorney's fees. So we have the backup in our prayer for relief, too. The question really is, in this setting, did we plead enough to survive? And if we did, the evidence has tracked what we have pled. And in fact, the evidence as it came in was even stronger than what we pled. We have texts where Ms. Brunner is texting with her board members that Rob Smijunas, the principal of Vanderkar, is an asshole bully, and she doesn't want to pay this money. They were getting lots of pressure about how this was coming in. So procedurally, you have a partial motion to dismiss that's based on I would say a technicality related to pleading that could easily be fixed. And then you have the record develop that supports the claim. And why wouldn't you want to resolve it on the merits rather than a technical pleading deficiency that can easily be fixed? And that we offered to fix if that's what the court thought was wrong. I mean, the question, again, the claim, the right to recover attorney's fees, I know the instinct. It's here. The Supreme Court has recognized it. Courts have used it in other settings. So the only question is, was there enough here? And then as the record developed, it gets stronger. So it should be remanded to be tried on that question.
And discovery has ended, correct? Had ended by the time the summary judgment motions were filed?
Correct. The original discovery cutoff was August 1st. It was extended for the port. Vanderkar filed its summary judgment brief.
So if we reversed on that point, would it be a summary judgment issue then at that point?
No. The court has already denied summary judgment. And again,
well, not on that ground.
Well,
right?
Not on that ground, true. But if the allegations are enough for a partial judgment on the pleadings, they track exactly what the evidence is. So there are disputed issues of fact on that. And I will say on this point, when Vanderkar...
Well, but I mean, there's a fundamentally different standard at the pleadings versus summary judgment, so...
Well, correct, but it's a disputed issue of fact, and they're not going to dispute...
Well, but that's what we just heard him saying about, like, if you make this distinction at the motion for judgment on the pleadings, you can't take it back at summary judgment.
Oh,
so, I mean...
I'm not saying that. What I'm saying is, if the evidence tracks the allegations, then there are disputes. The court isn't going to concede that they acted in bad faith. I mean, we know that.
No, but they might concede the fact. They might concede that, yes, this email was sent on this date, and the court then takes those undisputed facts and decides either it was good faith or it was bad faith.
So this is an interesting question that was not really briefed in the papers. When you have disputed issues of fact, it's kind of akin to negligence, right? The facts are not disputed, but whether it rises to the level of bad faith or whether it rises to the level of negligence, that goes to a jury. And I know they've cited a case that says, oh, this is not a jury question, but that opinion by Judge Rice doesn't grapple with this concept. And the question of bad faith in other settings, in insurance context, which I know is slightly different, and it's a tort claim, but the question of whether somebody acts in bad faith or not goes to a jury. And the jury can actually decide whether they want to award attorney's fees or not. So, again, the evidence, you're right. I don't even know that they would concede all the facts, quite honestly. But the issues about how the law developed, their denial that demolition is part of redevelopment when they are so publicly many times on record saying that demolition is part of redevelopment, we think is enough under the standard put in the case law about what is good faith and what is bad faith.
And you are also over your time, so unless there are other questions.
Thank you.
All right, thank you. Thank you all for your arguments this morning. We will take this case under submission and give you a timely written opinion. Thanks very much. Our next case this morning is State of Ohio versus Warren. Good morning. Mr. Smith is here on behalf of Mr. Torn. Mr. Cummings is here on behalf of the State of Ohio. Mr. Smith, you'll have 15 minutes to argue this morning. How much time, if any, would you like to reserve?
I'd like to reserve 5 minutes, Your Honor.
All right, I will keep your time whenever you're ready.
Thank you. Good morning, and may it please the court. My name is Brian Smith, and I represent the appellant Jamie Torn. Your Honors, this is an appeal from a denial of a motion to suppress. There were 2 separate issues that were contained within this motion to suppress. One was that the deputy did not have reasonable suspicion to stop the appellant's vehicle. The other was that the deputy did not conduct a valid inventory search of the vehicle after the stop. I'd like to talk first about the reasonable suspicion issue. This was based entirely on the window tint, allegedly obstructing the officer or the deputy's view.
Wasn't it also that the plate or the temporary tag was tilted a bit and that part of it was underneath or it was obstructed by the car itself? I mean, it wasn't just the tint, correct?
No, actually, Your Honor, the deputy testified it was based on the window tint obstructing his view. That he claimed that his testimony was inconsistent. He testified that it was based on the window tint obstructing his view and making it impossible to see this corner of the temporary tag. And it was, I believe, it was on page 16 of the transcript where he testified as to that. However, I'm sorry.
Isn't Judge Bach right, though, that he said the vehicle did have partially tinted windows and that the plate was obscured on the bottom right corner of it, making him not able to read it?
He did testify to that, Your Honor. However, his testimony was inconsistent because at one point, and it was actually the same page of the transcript, page 16, I believe, of the suppression hearing, he admitted that you could see, he called it the outline of the temporary tag. However, then he also said, but I couldn't see the expiration date because it was covered up. It was in the corner. And at one point earlier he had testified that it was, quote, pushed down. So I believe that was on page 6. So he contradicted himself, saying at one point.
Was there any pictures taken of how the tag was displayed that are in the record?
I don't believe there were pictures, Your Honor. I believe it was based
So
on
all we've got is his testimony.
I believe that's correct. I don't believe there were any pictures. However, at one point he says it's pushed down. At the other point he says the tint made it to where I couldn't see it. So but at another point he says I can see the outline. So the fact that he says I can see the outline implies that he can see around or see the edges of this temporary tag in the window.
Couldn't that have meant, maybe it was said in artfully, but couldn't that have meant that he saw the outline as in, a side and a top but not the entire thing?
I guess it would be up to interpretation, Your Honor. However, the way I would look at that is if he says he can see the outline, that it seems to imply an outline implies all 4 sides of something. So if you can, because obviously he does. If he says outline, then if he couldn't see all 4 sides and he says he saw an outline, technically he didn't see all 4. Technically, in this case, he didn't see all 4 sides, so technically it wouldn't qualify as an outline. And if the tag wasn't properly displayed, he could have mentioned, hey, this was, I saw something that looked like the tag, but it wasn't a complete outline of it. So obviously there's some ambiguity there. However, I would submit that in this particular case, the use of the word outline implies that he could see the entire thing. And I think that impacts the credibility of the deputy's testimony, where he's basing this on his observation of the temporary tag, or at least some portion of this temporary tag in the window. And I would point out also that the appellant was cited for, when this case was originally filed in the municipal court, he was cited for the display of the plate, but not the window tint. And there was never any testimony from the deputy as to checking this window tint. He based it on, it was based on eyeballing it, essentially. It was based, and it was done through traffic. He was asked about the weather conditions, and he said it was average weather. I believe he mentioned that he said, quote, there was no adverse weather. So it was kind of a cryptic way of saying it wasn't sunny that day. So at that point, so he's saying, you could interpret that as it was cloudy that day. Maybe conditions weren't perfect. So that also lends itself to to not being able to see this tint perfectly, which also calls into doubt whether which further lends credibility to the notion that he didn't have reasonable suspicion to stop the vehicle. I'd also like to talk about the issue with the inventory search. The state says that you've waived this argument by not developing it below. What's your response to that? Your Honor, it was raised below. The motion to suppress actually contained two separate paragraphs explaining both issues that were raised in the motion to suppress. They were covered at the suppression hearing, and the same issues that we're arguing today, which were that there was one paragraph focused on that there was allegedly no reasonable suspicion to stop. The second paragraph dealt with the warrantless search.
And then your position is the burden at that point shifted to the state to prove that it was a proper search.
Correct. Yes, Your Honor. The state bears, yes, the original motion complied with Criminal Rule 47. It laid out separate paragraphs for both separate issues. We would submit that was sufficient, especially when you look at the testimony from the hearing, that there was extensive testimony as to the inventory search, as to policy. The deputy was cross-examined on it. It was explored in depth in the hearing. So we would submit that was sufficient to preserve the issue for appeal.
Because I want to make sure I understand this, I'm going to ask the state probably the same question. Once the burden shifted, and your position is it was an improper search of the car, your position is the state at that point had the burden to establish that the search was proper. And they could do that either by showing it was an inventory search, they could show that it was proper because there was the odor of marijuana, for example. They could show it was proper because he consented. Your position is at that point the state had to establish why it was a proper warrantless search. And you didn't have to tell them it wasn't this, it wasn't that, it wasn't that.
Yes, Your Honor. The state bears the burden to show that the state is relying on the inventory search exception to the warrant requirement in this case. There was no testimony about an odor of marijuana. There was no testimony about consent. In fact, there was even a distinction made. The vehicle was not impounded. It was seized. And I think that's an important distinction to make here, too, that the deputy even admitted there was no impoundment of the vehicle. So at this point, they're going forward on inventory search and inventory search alone at this point. So they have to show that the search is done, quote, in accordance with standard police procedure.
And I'm a little confused on the timing of when the mother or mother-in-law, whoever, shows up at the scene. But is it your position that in a situation where the driver doesn't have a valid license and the detective is saying like, you're not allowed to drive, so we're going to seize this car. If the legitimate owner of the car shows up and says, wait, I'm here, I'll take care of it, can the state still proceed with seizing the car, or are they obligated to turn that over to the owner at that time?
I would submit in this particular case, I don't believe it's a categorical rule that they would have to turn it over in every case. However, in this particular case, the state did not conduct a valid inventory search. There was the key issue here is the department must have a policy governing governing inventory searches. The deputy, when he testified about this, made clear that it was his personal policy not to let a vehicle go.
But didn't he also say it was the department policy?
No, Your Honor. He testified, it was on page 23, it was, quote, my policy. And I believe on page 25, he says, if you go back and look at my record, there's never been a time in my entire career that I've let a vehicle go.
Well, he did say, and this, I wrote this down at least as a direct quote, what our policy is, an inventory search of that vehicle was conducted, any damage, anything. So at least he did at one point stick in the word our. I'm not suggesting that answers the question, but there was at least some mention of it.
And he also said, as far this is about the impoundment, not the search, but he says that's not the policy of the department.
He may have mentioned the department in a couple of his kind of off-the-cuff statements about the policy. However, they also never produced a written policy as to the Hamilton County Sheriff's Office inventory search policy.
Is that necessary?
I would
Under
submit
Beasley, is that necessary? Under the Beasley case, is that necessary to produce a written policy?
I'm not sure if Beasley dealt with a written policy. However, it does have to be a standardized policy, and I would submit that in order to show a standardized policy, there needs to be something in writing codifying what that policy is. Otherwise, it's not a standardized policy, because ultimately it's going to come down to a judgment call of whichever deputy or whichever officer shows up at the scene and decides, hey, I don't like the looks of this guy, I don't like what's going on here, we need to look in this car, so I'm going to seize the vehicle.
Actually, I'm sorry, I didn't mean, I misstated the case. State v. Smith, which was out of this court in 2021, said while those procedures, the Department of Procedures presented at trial, need not be in writing, and then it goes on to talk about what the state needs to show. Since it doesn't have to be in writing, what would you have, what to you would be enough?
I would submit that there has to be a clear rule as to when the inventory search is to take place. In this particular case, there was no testimony or no evidence offered as to the inventory search policy other than statements saying, this is my policy, I've never let a vehicle go. Yes, there may have been a mention of quote unquote our policy. However, it was clear at this point the deputy's relying on his own personal judgment as to whether to let this vehicle go. And I think it goes back to, he did this based on the appellant's BMV and criminal records, and also because he believed he had ties to this violent fugitive named Donald Torrin.
And you are over your time. We asked you some questions, so I'm not going to count it, but if you'll finish that thought, I'll
Yes,
reserve your 5.
Oh, thank you, Your Honor. And yes, and this was really what was underlying his decision not to let the vehicle go. He thinks that the appellant is somehow tied to this other person with the same last name, that he somehow has some sort of connection to him. And that's really what's underlying the decision to do an inventory search here, not a standardized procedure, as this court has found held to be the case in State v. Smith and State v. Ojale as well. I reserve the remainder of my time. Thank
All
you.
right, thank you. Mr. Cummings?
Good morning. Your Honors, counsel's absolutely right. There's very little testimony in the record about the inventory search policy. It's on page 11. That's about it. That's the only place where this deputy, who was probably one of the most experienced and knowledgeable deputies to do this type of work, that's the only place where it's briefly discussed. And that's very simple why. It's because this was not raised.
But he
in the motion.
didn't have to raise it. It's your burden to establish why a warrantless search falls outside of the requirements of a warrant. He doesn't have to guess what you might say it is. That's the state's burden to prove that it was an inventory search, or it was an automobile exception, or it was...
It was our burden to prove that the impoundment was lawful, and it certainly was here.
But the inventory, it was your burden to prove that the warrantless inventory search was proper.
Yes.
And what is the policy?
Well, what the record's going to reflect is probably like 20 pages out of 36 is a discussion about the tow. Was the impoundment proper? Was the tow proper? That was the whole gist of the argument. It was never about the inventory search
So
policy.
on what basis was the state arguing it was okay? What was your legal reason for saying it was okay?
Because the impoundment was shown to be proper, given the circumstances, because the defendant had a suspended license. He had an extensive history of driving without a license since 2016. He had just been pulled over not too
Let me interrupt you there.
Before then, yes.
Impoundment is different than search. They could have towed the car without searching it.
Correct.
They searched the car before they towed it. So what's the legal basis for the warrantless search of the car?
It's on page 11. Here it is in a nutshell. Once the state established a proper impoundment of the vehicle, or a tow, whatever word we want to use, then our burden for an inventory search was it done pursuant to a policy?
Let me stop you there. What is the policy? From this record, what's the policy?
The policy was not admitted into evidence.
Or testified to?
It was testified to on page 11. The officer said, after I just determined to impound the vehicle, which I claim the record will support as legal, the officer then testified on page 11 that once we impound the vehicle, we inventory search it. And it's pursuant to a policy, and I've been doing this for years. We have to account for valuables, we have to account for public safety, we have to account for damage. And he testified that he did it pursuant to that policy. And the trial court found not only did he do it pursuant to the policy that he referenced, but that it was not a pretextual search. This was a very straightforward search. This is not the type of case where we're dealing with a closed
But he's
container
not
case.
he's not searching, he's doing an and I know, I was on the panel, I don't remember which case it was, where we had a similar fact pattern, and there was no testimony that the officer was writing down what he found.
Yes.
I mean, we don't have any of that.
Yeah, that was
I think that was
Beasley.
Beasley.
Okay.
But
And how do you distinguish Beasley? And I think that goes along with Judge Meyer's question. How do you distinguish Beasley from this?
Well, in my opinion, Beasley's an anomaly. I think if this court actually addressed this issue before Beasley and Butler, a very similar situation, and the officer testified about the inventory policy, and the court said the fact that there was no written policy entered into evidence is irrelevant, since no objection by defense counsel was ever made to the officer's testimony regarding his understanding of the policy.
Well, but we don't have even the understanding of the officer's policy here. I mean, I don't know what the policy is. Is the policy to open the glove compartment? Is it to search the trunk? Is it to write everything down? Is it to, I mean, a policy isn't just we can search, is it?
Yes, the case law does not say that the state has to enter into a policy that says A, B, C, D. That's not what the law requires.
Well, but I think Beasley's pretty clear that there has to be something more admitted into evidence, whether by testimony or by written documents, to substantiate that there is something that constitutes a policy. In other words, it's not just on the officer's whim, I'm going to do it this way, I'm going to do it that way. And I mean, I thought we were pretty clear in Beasley that needed to be proved up.
I agree. I think a fair reading of Beasley, you do come away thinking that this court requires a written policy to be admitted. And I think that's untethered from the Ohio Supreme Court.
No, but that's not what I said. I said it could be adduced by testimony. Like you could have the officer on the stand and you could say,
Right.
here's our policy. We have to do this step first, we have to do that step second, then we have to write everything down, and then we send the vehicle. Like,
Right.
there, you've got the policy, it's established. And Beasley said that's okay.
Right.
But what Beasley's looking for is an actual policy, not just, hey, I've got a vehicle here, I'm going to search it.
Well, I think there's a gray area there. I think the Supreme Court has said the state has to show that the search was done pursuant to a policy that's established by the Sheriff's Department, and it has to be done in good faith. And I think a fair reading of this transcript allowed Judge Dinkelhocker to say, you know what, this Deputy Singleton was right. He did a search, it's pursuant to the sheriff's policy, and he certainly did it in good faith. This comes down ultimately to reasonableness, and under the Fourth Amendment, is it reasonable to just search the interior of a truck that you're going to impound? He didn't check the trunk. He didn't look into a locked safe or a closed container or a backpack. He just checked the side door panel of the passenger side and found a gun. That is the ultimate in reasonableness. This court would have to say that Judge Dinkelhocker committed an error of law by finding it was unreasonable to search the interior of that cab. I just don't think that this is a case where you can say that this was an unreasonable search under the Fourth Amendment because the state complied with what the law requires. We showed the impoundment was valid. The officer said, I searched pursuant to a policy that the sheriff has.
No, he didn't say that much, though. He just used the word "our policy."
Okay. I guess the question is it a fair reading of that for Judge Dinkelhocker to assume that that is true, that the Sheriff's Department has a policy and this was performed pursuant to
Let me
that?
go back there, though. A policy, what is the policy? Is the policy we conduct an inventory search every time we impound a car? Is it I don't know. I
understand.
can speculate, because I've been around a while, on what the policy might be. But how, when I'm looking as a judge at this record, can I determine what the policy is?
You can't. You're not going to glean from this record what's in the Sheriff's Department policy because the defense counsel didn't pursue it, didn't
Or
care
why
about
it even applied here?
But it was your burden as well. I mean, it wasn't the defendant's
It
burden,
was
it
our
was yours.
burden to show that this was a proper inventory search. And all the case law requires, if you look at Hathaway or Leak, is that the search was done pursuant to a policy, which the officer said, the sheriff's office has a policy, and I didn't do it as a pretext. I was doing this on the up and up. That's all that has to be shown. And I think that this record clearly supports Judge Dinkelhocker's determination that, yeah, this was done to a policy. He did it right, and this wasn't pretextual. He didn't have any type of ulterior motive. This was done on the up and up. And this is the ultimate in a reasonable search, the interior of a car when you're going to impound it due to the public safety. The caretaking duties.
Well,
of
I
the
guess,
officer.
going back to the issue about the defendant's mother showing up and saying, and I forget the exact timing of when she showed up, but saying like, hey, I'm here, like, don't tow the vehicle, like, give it to me. Like, would the policy then help us understand why the car was not turned over to her, but why it was continued to be seized? In other words, like, do they have, is part of the policy to say, like, if someone shows up and says they own the car, we immediately give it to them, or we immediately do not? Or, you know what I'm saying?
Yes. I don't know. I don't think that decision is going to be governed by each agency's policy as much as it's governed by statute. And here there's a statute that says once law enforcement comes legally into the possession of a forfeited vehicle or a towed vehicle, then they have the option to seize it if they want to. It's a discretionary call by statute, and I think that's cited in the briefs. I don't know if each individual agency's search policy would even speak to that type of an issue, but I think that the officer will always maintain discretion under the statute to impound a vehicle that he's lawfully come into possession of. And I think here he goes out of his way to explain why he did it. because this gentleman had been driving without a license for 3 or 4 years. He'd been pulled over recently in the same car. So the policy of the department and this officer's policy, he did say that. There's no way in heck this guy's getting this car back, and that's reasonable, given the circumstances. And I think under the statute, that was certainly within his discretion, and I think that was certainly proper as well. Clearly, I think I said this in the brief, if this court's going to require a written policy be instituted in every one of these cases, this is going to be reversed, absolutely. But I don't think the law requires that.
I don't think the law requires that either. But my question for you is, it doesn't seem like this is distinguishable from Beasley. So are you saying that we should say Beasley isn't good law?
I don't think you have to do that. I think Beasley says there was no evidence presented regarding the policy that he was relying upon. It was not introduced. He did not testify as to the details. Without that evidence, the state can't meet its burden. I mean, technically, if you follow Beasley, you could reverse this case, yes, because the way this Beasley could be read that way, yes. I don't think you have to read it that way. I think you can point to page 11 of the transcript here and say there was evidence that Judge Dinkelhocker could rely on. This officer said, yeah, once I have an impound vehicle, we have a policy, I have a policy, I searched it pursuant to that policy, and it was done in good faith. And I think, to the extent Judge Dinkelhocker had to infer or imply everything was in good order, I think it's just because this was not a record that was well developed. This was not the focus. If you look at the closing arguments of counsel at this hearing, it's all about the impoundment. This was an illegal impoundment. His mom was there. She could have driven it home. It was legally parked on the street. Let's let it stay there. That was the gist of his presentation. He couldn't have cared less about an inventory policy. And under this court's case in Billings, it says arguments not made or pursued by a defendant at a suppression hearing are deemed to be waived. I mean, once the officer testified that he did this according to an inventory policy, defense counsel should have objected according to Billingsley. He should have developed the record. It wasn't done. It was forfeited. I think the court understands the state's position on this. I don't want to beat a dead horse, but if you have any more questions.
Any questions? No.
Thank you very much.
Mr. Smith, you have 5 minutes remaining.
It was raised. It was raised in the original motion, and that was the reason that this testimony even came out about the inventory search, was because that the issue of the warrantless search was raised. And I think I think we have to make sure that we don't change the standard to reasonable here. It's about it must be a standardized police procedure. We're not here to decide whether this search was reasonable or not. So I think it's clear that we need to stay on track here. This case is just like Beasley, because the state didn't meet its burden to show a standardized procedure, and that's the bottom line. They didn't develop the record. They could have produced a written policy. They didn't. Yes, it's not this court doesn't require a written policy. However, the state could have gone a lot further to develop the record here and show why this was a valid search, other than relying on a few statements from the deputy at the suppression hearing. They chose not to do that. And they were put on notice that this was going to be an issue because it was in the motion to suppress that was a written motion to suppress that was filed well before the suppression hearing. So the state was on notice. They could have produced more. They chose not to do so. There was no reason for defense counsel to object, because the state was producing evidence, or at least attempting to meet its burden to show why this was a valid search. So there was actually no reason to object. And I would also point out that the word "our" doesn't necessarily mean the department. I think there may have been one mention of the department. However, "our" could mean me and the other deputy's policy, could mean the policy of every sheriff's deputy in Ohio, could mean every law enforcement officer in the United States.
Well, a reasonable inference in that context would be that it was the sheriff department policy. Wouldn't it?
Yes, but
I guess that was a question, wouldn't
yes,
it?
but "our" is a vague. There is some ambiguity with that term, and it's more than just this court's ruling in Beasley that requires a standardized procedure. It's also State versus Hathman And also, the Ohio Supreme Court in State v. Leak and in Blue Ash v. Kavanaugh has said the same thing, that there has to be a standardized procedure. And I'd also point out the defendant's record doesn't, or the appellant's record doesn't justify an inventory search here. It goes, that's not what an officer is looking at. It's about the justification for an inventory search goes to the community caretaking function that we trace back to Katie v. Dombrowski with the U.S. Supreme Court. So it doesn't go to the appellant's criminal record or anything specific to the appellant. It's about that, at least philosophically, it goes back to that community caretaking function. So for the state to rely on the appellant's record or the appellant's suspended license as the basis for an inventory search, I think is off base here. And I think that goes against the justification for an inventory search.
So it's administrative rather than investigative.
Correct.
And, go on, sorry.
Oh, no,
You have about 30 seconds left.
Yes, I'll just sum up very briefly that it was raised, it was properly raised. There were separate paragraphs. This issue was raised, and we're asking the court we're not asking necessarily for we're not even asking the court to overrule Beasley. We're asking the court to follow its prior precedent in Beasley and to find that the state has to meet its evidentiary burden to show that this was done in accordance with a standardized police procedure. Not necessarily a written procedure, but a standardized procedure, and that burden was not met here. We would ask this court reverse remand. Thank you.
Thank you.
If there are any questions.
Thank you.
Thank you.
Counsel, thank you both very much for your arguments this morning. We will take the case under submission, give you a timely written opinion. That will conclude our arguments this morning for the First District Court of Appeals.
Court of Appeal for the District of Ohio.